Did you know that in the UK, over 30% of young offenders reoffend within a year? Did you know that England and Wales have the highest rates of youth imprisonment in Western Europe? These shocking statistics highlight a critical issue within the UK's juvenile justice system. Understanding how young offenders are treated is crucial for addressing the root causes of juvenile crime and improving the prospects of rehabilitation and reintegration into society. The UK's approach to juvenile justice has evolved significantly. In the early 20th century, the focus was primarily punitive, with young offenders often treated similarly to adults. The introduction of the Children and Young Persons Act 1933 marked a shift towards recognising the need for a separate system that considers the welfare of young offenders. Over the decades, this focus has continued to evolve with the Crime and Disorder Act 1998 and the Youth Justice and Criminal Evidence Act 1999, emphasising prevention and rehabilitation. Understanding the treatment of young offenders remains vital. The system's effectiveness in rehabilitating young offenders can significantly impact crime rates and societal safety. Moreover, it reflects a society's commitment to providing second chances and supporting the vulnerable segments of the population. One of the most infamous cases in the UK's juvenile justice history is the murder of James Bolger in 1993 by two 10-year-old boys, John Venables and Robert Thompson. This case brought the age of criminal responsibility into sharp focus and ignited debates on how to balance justice and rehabilitation for young offenders. The Children and Young Persons Act 1933 laid the groundwork for modern juvenile justice, emphasising the need to protect young people from harm and ensure their welfare. The Crime and Disorder Act 1998 established youth offending teams, YOTs, multi-agency teams aimed at preventing youth crime and supporting rehabilitation. The Youth Justice and Criminal Evidence Act 1999 further reformed the system by introducing youth courts and special measures to protect young witnesses. Despite these legislative efforts, young offenders in the UK face numerous challenges. The high reoffending rate suggests that current rehabilitation programmes may be insufficient. The Legal Aid Sentencing and Punishment of Offenders Act 2012, LASPO, introduced changes that, according to critics, have reduced the support available to young offenders, making rehabilitation more difficult. The overrepresentation of minorities in the youth justice system is another significant challenge. Studies have shown that young people from black and minority ethnic backgrounds are more likely to be arrested and sentenced than their white counterparts, indicating systemic biases that need to be addressed. There is also evidence that young offenders often come from disadvantaged backgrounds, and the system may not adequately address these broader social issues. Moreover, the availability and quality of rehabilitative services can vary significantly across different regions of the UK, leading to inconsistencies in how young offenders are treated. Furthermore, many young offenders have underlying mental health issues that are not adequately addressed within the current system. Recent changes in the juvenile justice system have not always been positive. The reduction in funding for YOTs and rehabilitation programs due to austerity measures has been widely criticised. These cuts have limited the resources available for supporting young offenders, potentially contributing to the high reoffending rates. Moreover, the age of criminal responsibility remains a contentious issue. At 10 years old, it is one of the lowest in Europe, drawing criticism from human rights organisations who argue that it does not align with international standards for children's rights, and that children at such a young age lack the developmental maturity to be held fully responsible for their actions in the same way as adults. The current approach to handling young offenders in the UK involves a mix of diversion programmes, community service, and custodial sentences. Diversion programmes aim to keep young offenders out of the formal justice system by providing interventions such as counselling, education, and family support. Community service orders and youth rehabilitation orders, YROs, offer alternatives to custody, focusing on rehabilitation within the community. For more serious offences, custodial sentences like detention and training orders, DTOs, are used. These sentences combine time spent in custody with community supervision upon release, aiming to balance punishment with rehabilitation. There are strong calls for reform within the juvenile justice system. Advocates argue for raising the age of criminal responsibility to at least 12 or 14, in line with international standards. There is also a push for increasing the use of restorative justice practices, which focus on repairing the harm caused by crime, rather than simply punishing the offender. Opponents of these reforms argue that raising the age of criminal responsibility could result in younger offenders escaping accountability. They also express concerns about the effectiveness of restorative justice in dealing with serious offences. The UK's juvenile justice system faces significant challenges, including high reoffending rates and insufficient rehabilitation programmes. While recent legislative changes and funding cuts have negatively impacted the treatment of young offenders, there are ongoing efforts to reform the system and improve outcomes. Effective rehabilitation and support are crucial for preventing reoffending and ensuring that young offenders can reintegrate into society successfully. Addressing these issues requires a balanced approach that combines accountability with a strong focus on rehabilitation and support.